Okay, everybody, let's finally get into evidence. Okay, this is our first video on evidence. We're going to talk about witness competency to testify. Okay, it's a fairly straightforward concept, so let's dive into it. Our outline are these 6 rules, Federal Rules of Evidence 601 to 606. Okay, again, it's fairly straightforward. We're going to translate this into English. Okay, so we'll start with Federal Rule of Evidence 601. Federal Rule of Evidence 601 is competency to testify in general. Okay, what does this mean? The general definition of this rule is every person is competent to be a witness unless these rules provide otherwise. And the rules that will provide otherwise are Rule 602 to 606. Okay. Fun fact, under common law, people declared not to be competent to stand trial are people who did not believe in God, people who had prior felony convictions, and young children. Okay. The young children part will be straightforward in our rules to come, but under the common law, young children were not declared to be competent because, again, they're too young to fully comprehend what to do when they're on the stand to testify. So Federal Rule of Evidence 602, need for personal knowledge, okay? The definition is a witness may testify to a matter only if evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. What does this mean? This means that, okay, we have a witness on the stand in trial. That person must have had some type of personal knowledge of what happened, whether it's a civil suit or a criminal case, right? And there must be evidence introduced to support whether or not that person really has this personal knowledge. If there's no evidence that the person had personal knowledge of what happened, this person will not be competent to stand trial. However, if there's a police report, let's say, that states that the officer talked to John, then John will be declared to be competent to stand trial because the police officer talked to John about what happened during the crime scene. That's why John would be a good person to go on the stand. Furthermore, one thing to note, which is very critical here, is that all witnesses can only testify if they have personal knowledge through one or more of their 5 senses, right? So let's say John saw what happened. That is one of his 5 senses. Let's say John was in the store and the door, the front door of the store was open and he heard someone get into a fight or he heard a gunshot. That is an example of John having sufficient knowledge, personal knowledge on what happened during the crime, and he will be a competent witness to stand trial. Another example of Federal Rule of Evidence 602 is that Lamont robs Rebecca, okay? Michael sees and hears the robbery occur. Let's say that Lamont is the guy right here with the ski mask, and the woman in the purple here is Rebecca, and the guy with the cool sunglasses and the top hat is Michael. Michael is a qualified witness to stand trial because he has personal knowledge of what happened because he literally saw what happened, right? And most of you may know that, of course, when the crime happens, police are involved and police talk to everyone who was present at the crime scene. So therefore, not only will Michael be a competent witness to stand trial, Rebecca will be too because she was the victim of the crime. She saw and heard what happened. Therefore, because one or more of her senses and one or more of Michael's senses were able to indicate to them personal knowledge of what happened during the crime, they will be competent witnesses to stand trial. Therefore, they will satisfy this rule, okay? So let's dive into Federal Rule of Evidence 603. Oath or affirmation to testify truthfully, okay? Definition, very simple. Before testifying, a witness must give an oath or affirmation to testify truthfully. So anyone who refuses to take the oath, they will not be able to testify, okay? So we go back to our example up here. If Rebecca and Michael here refuse to take the oath that they're going to tell the truth once they stand trial, they will not be competent witnesses, okay? If they do take the oath or affirmation that, hey, I will tell the truth to testify, whatever I say will be the truth, then thumbs up, right? Great. They will be able to testify and they'll be a competent witness to stand trial. Lastly, a judge might find that a child is unable to testify if it is determined upon examination that the child does not understand or appreciate the oath. Okay, so some children will be able to fully understand what a truth is and what a lie is. Okay, really, this happens when children are, probably under, I say, 6, probably under 5 years old. That's when it'll be declared that child won't be able to fully understand or appreciate the oath. Okay, but children who are around 10 or 11 years old, they understand what a lie is at that point in their lives. They understand what the truth is, right? So again, if a judge, the judge will test the kid, right? For example, the judge will say what a lie is, what a truth is, and the kid will have to answer those questions. If upon examination, the judge determines that the kid understands what a truth and a lie is, and the kid is still willing to testify and take the oath, then that kid will be a competent witness. Okay. This is what it'll look like in court. Okay, let's just pretend that this woman right here is either a child. This is clearly the judge. We all know that. But let's say this is Rebecca or Michael testifying against Lamont. Because again, they saw and heard what happened during the crime. Therefore, as I said earlier, they will be competent witnesses to stand trial. Or even if this woman, let's say this is a little girl, is taking the oath, that's what it'll look like. That will be a situation where that person will be a competent witness to stand trial. And again, there must be evidence shown that, hey, this person actually has personal knowledge. It can't be Michael's mother. It can't be Rebecca's boyfriend. If they don't have personal knowledge, and if there isn't evidence introduced to show that they actually have personal knowledge of what happened, they will not be a competent witness to stand trial. Okay. So let's get into Rule 604. Very straightforward. An interpreter must be qualified and must give an oath or affirmation to make a true interpretation. So this means that, hey, we need a qualified interpreter who will properly interpret what the defendant or the witness will say on the stand. And that interpreter must also make an oath or affirmation that he or she fully understands and make a true interpretation of what that person is saying. In court, it usually looks like this. As you can see, the defendant is in the blue and the interpreter is in the black, speaking to the microphone to the judge here to tell the judge what exactly this person is saying. So let's say the person in the blue is a Spanish speaker only. This interpreter here will make an oath or affirmation that, hey, judge, I understand Spanish and English. I'm a qualified interpreter, and I'm going to tell you the truth and nothing but the truth about what the defendant is saying here. I'm not going to twist and turn the words. Another straightforward rule, Federal Rule of Evidence 605, judge's competency as a witness. This means that the presiding judge may not testify as a witness at the trial. Okay, whether it's a criminal case or a civil case, the judge, him or herself, can't be a witness. It's just a general rule, okay? And lastly, Federal Rule of Evidence 606, juror's competency as a witness. A juror may not testify as a witness before the other jurors at the trial. If a juror is called to testify, the court must give a party an opportunity to object to the jury's presence. So that means that, hey, if counsel or the state, the plaintiff or defendant, calls one of the jurors to stand trial, the rest of the jury box cannot be present during that time. So this is really a situation where, okay, it'll be on the record, fair enough, and the judge will hear it, fair enough, because the judge is another individual who will be deciding either damages or a verdict for guilty or not guilty. Therefore, one of the jurors be on the stand is very critical if that juror is competent and relevant to the case. But again, the other jurors cannot be present in court while that juror is being called as a witness. There's a caveat here. We have prohibited testimony. So prohibited testimony really means that a juror cannot testify about any statement or incident made during the jury's deliberations. the effect of the votes that each juror made in determining guilty or not guilty, or whatever damages that the plaintiff is desiring for the defendant. And the juror who's on the stand may not testify about any of the juror's mental processes about the verdict. An exception to this rule is that a juror may testify about an outside influence that was improperly brought on any juror or mistake made in the verdict on the verdict form. So this really means that, let's say a juror is called in the stand to testify. The exception to the rule of prohibited testimony is that, hey, if the juror noticed that one of the other jurors are only saying guilty because that person is, let's say that person is threatened by another outside of the courtroom, that, hey, I will kill you if you don't vote not guilty, or I'll kill you if you vote guilty. Right? That's an outside influence that's improperly affecting the juror's mental process in determining guilty or not guilty. So that's a situation where a juror may actually tell both lawyers and also the judge on what happened there. Lastly, it's possible that this happens, this is rare, but it's possible that a juror, him or herself, who's on the stand, or other jurors may have made a mistake on the verdict form to say guilty, but the person really meant to say not guilty. That's where a mistake made on the verdict form could possibly happen. And that's where a juror who's on the stand can tell both lawyers and the judge on what happened. And remember, during this entire rule of 606, other jurors are not present in court. They have to be out of court. They can't be present. Okay. So this is very critical to understand. So to wrap this up, witness competency focuses on rules 601 to 606. Okay. Remember the examples. The examples are very helpful in order to understand what these rules really mean. Especially the fun examples, because a lot of the examples that I use are examples of my own friends who I personally know in real life. So I say, even when it comes down to interpreting language, when it comes down to taking the oath, and even when it comes down to Rebecca getting robbed by Lamont and Michael witnessing what's happening, that's why he will be a competent juror, because he has personal knowledge about what happened. These are situations where you can use these examples to really understand these rules in a deep way. So try to make examples, like I said, like this one, and taking the oath, and like I said, interpretation, because this will really help you understand the rules. And let's just be honest, you know, memorizing these rules by writing it down, and also flashcards would be very critical. Okay, that's why, as you can see, I have a pretty nice stack of flashcards. Very helpful stuff to understand the rules word for word. Okay, if you have any questions, comment below. The next video, we will talk about character evidence. Okay, for now, thank you.